It's always a great pleasure to read the work of Bode and Sachs. Their work brings to mind great collaborations of the past: Fuller and Purdue, Hart and Wexler, McGinnis and Rappaport. But I'm told that I'm here to comment critically. So while I'd prefer to spend my time plying the authors with encomia, the organizers have insisted on gentle criticism. So here we go. We all know the 11th Amendment scholars divide into three branches. We have the diversity branch, which holds that the amendment forecloses only diversity-based litigation, leaves the federal judicial power intact as to all claims brought against states that arise under the Constitution, laws, and treaties of the United States. We have the Seminole Tribe branch, which holds that states enjoy a general immunity from suit that predates the 11th Amendment and extends well beyond its terms, that governs litigation in state and federal court, that operates as a constitutional barrier to suit, yet remains subject to limited congressional override under the 14th Amendment. These judge-made radiations amount to 11th Amendment penumbras, and they make an obvious target of classroom sport. We have the literal branch, which tries to argue that the amendment means what it says, no more, no less. Bode and Sachs offer a new synthesis of the literal view coupled with an exceedingly muscular conception of the state's common law immunity from suit. We agree on much. In fact, literalists and diversity theorists have been described in the past as having a friendly debate. And that's the way I see it here. We both agree that the 11th Amendment is much narrower than the size to which the Supreme Court has puffed it up, and that it cannot, understood properly, be either waived or abrogated. But I think Bode and Sachs have both the common law and the 11th Amendment wrong. Let me begin back in the 1780s, a time when leading jurists were far more open to the idea of state sueability than the authors might allow. And then I'll step back from the era of the early republic to talk a bit about the implications of the theory for current law. Conclude with a puzzle. Why do relatively conservative, originalist-minded scholars and jurists today, both off and on the Supreme Court, work so hard to defend a doctrine of state sovereign immunity that relatively conservative, relatively formalist jurors of the 1780s and 90s were only too willing to put aside? Let me begin by questioning both the Seminole Tribe idea that the Constitution incorporated unwritten protections of state immunity and the Bode and Sachs idea that such immunity was embedded in a super strong or super duper form of common law. What was going on in the 1780s? From the perspective of the Federalists, the states were behaving badly, especially state legislatures. They were issuing paper money, adopting tender laws, refusing to pay their share of the requisitions. They were refusing to honor debts and contracts, especially to British nationals, taking the property of loyalists, allowing their citizens to pay off debts in depreciated currency, pennies on the pound. True, state legislative assemblies held the power of the purse. There was no common law right of action that ran against the state as such, but the national impulse that drove the Federalists to Philadelphia sought to bring the states to book along all these dimensions, depriving them of the right to coin money and print paper and tender laws, and barred the impairment of the obligation of contract. Nothing could be more in keeping with the idea of making states honest than provisions for state sueability. So here's the puzzle. Conservative jurists in the 1780s and 90s were all about state sueability. It was the tool to make the guarantees of the Contracts Clause and other provisions effective. Let's evaluate the claim in Seminole Tribe and the super strong conceptions of common law immunity by putting the question to the state and early federal legislative assemblies during the period. Back then, internal state politics were shifting from legislative claim processing through petitions to judicial claim processing through courts. 7 states allowed those whose property was forfeited to reclaim that in suits brought in courtrooms. 4 states, New York, Pennsylvania, Virginia, and Georgia, went further, creating a form of general purpose mechanisms by which individuals could sue states in court. Virginia's statute is interesting. It was adopted as part of the Chancellor's Revisal in 1785, a set of reforms that emerged from a committee on which Pendleton, Madison, and Jefferson all served. Jefferson wrote the statute, modeling it on the British Petition of Right and providing that a court shall proceed to do right on any claim in law or equity brought against the Commonwealth. So much then for the idea that state sueability was unthinkable before 1787. In truth, many members of the founding generation thought state sueability a worthy reform, and all it took was simple legislation to overcome common law immunities. We all know what happened at Philadelphia. The framers agreed to add provisions to Article 3 that obviously contemplated suits against states. Such suits could be brought by the United States, by other states, by individuals, either on the basis of diversity or alienage jurisdiction, or on the basis that they arose under federal law. These provisions attracted controversy. When the Anti-Federalists argued the Constitution would reduce the states to mere corporations, they had in mind these sue and be sued provisions of Article 3. They also attracted some unpersuasive rhetorical maneuvers, such as the arguments by Madison and Marshall to the effect that the provision allowed the states to sue, but not to be sued. One can still hear Patrick Henry thundering in the words that maybe the Alden Court should have considered. What says the paper? If gentlemen pervert the most clear expressions and the usual meaning of language, there's an end of all argument. But notably, the assertions were made in debates over the meaning of the diversity provisions. I know no evidence that anyone debated or denied the sueability of states in federal question matters, as to which the federal Constitution specified an enforceable restriction on state action. What happened after Philadelphia? Congress passed legislation, the Judiciary Act of 1789, that included two relevant provisions. First, Section 13, authorizing original jurisdiction over controversies of a civil nature in which the states were party. And then there was the All Writs Act, authorizing courts to fashion writs to effectuate their jurisdiction. When suits began to appear on the court's docket, guess what? The court issued process to the states. That was well before the decision in Chisholm, which was, of course, the first case to uphold the sueability of the states under Article 3 as a formal matter. To me, the lawmaking process that led to the adoption of the Act of 1789 answers two questions. It shows the states lacked any constitutional immunity from suit as to matters embraced in Article 3. It wasn't just four misguided justices on the Supreme Court. It was the members of the House, it was the members of the Senate, it was the President of the United States who voted for and signed the bill into law. Why, one might ask, doesn't this represent a kind of decision of 1789 on the subject of state sueability? Second, it shows that the common law immunity of the states was perhaps a bit less muscular than the one that Bode and Sachs imagined. Indeed, like other unwritten rules of common law, the state's immunity from suit was overcome by the adoption of statutes. Justice Iredell initially argued that there was no such statute to point to, but Wilson observed that the All Writs Act served as a source of authority. And Iredell was then reduced to arguing that the act didn't confer sufficiently explicit authority to allow the exercise of power in relation to the states. But the court rejected Iredell's argument, so much for the common law immunity. And even after the 11th Amendment put Chisholm to bed, the court continued to rely on the statute as the basis for calling states before the court in the exercise of its jurisdiction over disputes between two or more states. So where the court's jurisdiction was left unimpaired and contemplated suits against states, common law immunity posed no barrier. I'm actually drawn to a quote from a paper that appeared in the Harvard Law Review back in 2017 that says, statutes, of course, trump unwritten rules, just as a new statute trumps an old one. That, of course, was written by our friends Will Bode and Stephen Sachs. Now consider the adoption and meaning of the 11th Amendment post-Chisholm. We all know that the Senate rejected a sweeping prohibition against state sueability. We know that it instead adopted the more modest terms of the 11th, and that shows signs of compromise. Diversity theorists say that the compromise curtailed party-based jurisdiction over controversies, but left federal question jurisdiction intact. Literalists argue that the compromise cut more deeply, foreclosing federal question claims by the two disfavored litigants. But literalists have a hard time explaining the logic of such a compromise. Why curtail federal question claims by disfavored plaintiffs? There was once an assignment theory, but it has been debunked. Out-of-staters bringing federal question claims posed no current threat to state treasuries because the obligations sued on had been incurred before the Constitution was ratified and took effect. Federal law posed no threat to claims that antedated the ratification date of the Constitution. Curtailing diversity, on the other hand, did end that threat of retrospective liability. One can understand the compromise this way. We'll let the states off the hook for the debts they incurred during the Articles of Confederation. Hamilton's Treasury is arranged to assume those debts anyway, but in keeping with the commitment to bringing the states to book in the Constitution, we'll hold them honest going forward on federal law matters. Some argue against this understanding by suggesting no one at the time perceived a distinction between diversity and federal question. But that's bunk. First of all, many folks criticized Chisholm for its retrospective character. The list includes Pendleton, a justice of the Virginia High Court, governor of Georgia, the Virginia House of Delegates, Governor Hancock of Massachusetts. Its retrospective features put Federalist supporters in an awkward position because they promised ratifying conventions that the Constitution would have no retrospective effect. The distinction between diversity and federal question appeared in the work of Edmund Randolph, both as he argued on behalf of Chisholm and highlighted the need for the enforcement of constitutional limits in his 1790 report on the judiciary. Pamphleteers admitted the importance of enforcing constitutional limits. Representative John Davis argued in the Massachusetts House that Chisholm went too far, but he supported the view that constitutional limits needed to be enforced. A couple of comments on text and a few more elements, and I'll try to wrap these up as quickly as I can. One of the arguments in favor of the literal view is that that the framers didn't curtail the exercise of jurisdiction over controversies, but they couldn't do it because the states wanted to maintain their ability to sue individuals on the Supreme Court's original docket. In fact, Georgia had such a case pending in the Supreme Court's original docket and wouldn't support an amendment that would curtail jurisdiction over controversies. So they did the next best thing. They foreclosed the only kinds of suits in controversies that could have been brought by the plaintiff, suits in law and equity, brought by the disfavored plaintiffs in diversity proceedings against one of the United States. About the Gallatin Amendment. I'll skip over a few of the intervening points, but the Gallatin Amendment's really interesting. Here's another possible way to think about it. Suppose Gallatin shared the perception of the compromising senators who'd signed on to a diversity-only theory of the 11th Amendment. So the senators understood that Chisholm was essentially retrospective and the diversity account of the 11th Amendment would curtail that threat to state treasuries. The language of the 11th foreclosed all retrospective common law proceedings, including Vassal against Massachusetts, the treaty-based claim up against the state of Massachusetts. Perhaps Gallatin was reasoning that treaty obligations were in fact retrospectively enforceable under the current law and should remain retrospectively enforceable in common law actions under the 11th Amendment after it was ratified. If you view the Chisholm-based common law diversity proceeding as the vehicle for such enforcement, Gallatin may have been trying to preserve retrospective suits by foreign nationals to enforce the Treaty of 1783. His amendment refers to treaties made under the authority of the United States rather than treaties which shall be made under this Constitution. So he had in mind retrospective application. I have, unfortunately, too many more things to say. And so I'll quit saying them right now. I think, unfortunately, the 11th Amendment remains misunderstood.
Well, that's clearly true one way or another, because we can't both be right. So just a couple things before we get to questions. So I think sovereign immunity has the good fortune and misfortune of being something that everybody wrote a lot about and thought a lot about before the Constitution was ratified, while it was being ratified, and after. So we do have the advantage of having a lot of material to work with, but it means that different assumptions about different stages of the process can carry over pretty quickly. So the way we see it, the pre-constitutional status quo was a common law rule that states couldn't be forced into court. Because it was a common law rule, states were quite free to set up other systems. It wasn't that there was something wrong with states being in court, it was just that it was up to them to decide whether they wanted to be there, whether they wanted to handle it some other way. The debate at the ratification was whether or not, instead of the states getting to decide, the new national government or the new constitution was going to decide for them by forcing them into court when they didn't want to be. And as much as I like Patrick Henry, I read Madison and Marshall's responses that you shouldn't read Article 3 as erasing other rules of personal jurisdiction and capacity. And his examples were, what about a child? What about, at the time, a married woman, people who under the common law couldn't sue? Does Article 3 suddenly upend all that? Doesn't seem like it. I think as a lawyerly matter, that made a lot of sense. If you don't think that makes a lot of sense, then everything else that follows is strange. Under that rule, that means the states still were the ones to decide. Article 3 didn't decide for them. When the court says in Chisholm that Article 3 and Congress will decide for them, the 11th Amendment is necessary to undo that. We can explain why was the 11th Amendment so important and why was it so cross-cutting, and yet why didn't it go further? Why didn't it reach federal question cases? Because the premise of the 11th Amendment is that Chisholm was wrong. But it adopts, as Steve said earlier, a chainsaw rather than a scalpel or an eraser pen to do that. So it ends up doing much more than overruling Chisholm, creating this big subject matter barrier. I agree it's possible to explain the Gallatin theory through this slightly complicated set of steps. I do think, the more natural reading of the exchange is just, here is this thing that will cut off jurisdiction. Gallatin says, wait a minute, shouldn't cut it off over treaties. Everybody else says, nope, should cut it off over treaties. Gallatin says, I dissent, and they move on and adopt the 11th Amendment. If the text of the 11th Amendment favored the diversity reading, I'm not sure that would be enough to move me the other way around. But given that the text of the amendment just talks about cutting off the judicial power of the United States, this exchange sort of strengthens that for me. But curious to see what the room thinks.